Hi, everybody. Welcome to Insights from Case Text. I'm Mike Whalen here in the WeWork Kansas City studio. During this series, I'm talking to my friends about writing for lawyers. Today, I am talking to Jordan Couch over in Washington. How are you today, Jordan?
I'm doing great. How are you?
I'm pretty good, and I appreciate you joining me. To get started, I always like to ask people to rant a little bit. Give me some goods. Tell me what's on your mind.
So it's funny because, we're here talking about legal writing, and actually my big problem with the entire concept of legal writing. I think it's a fiction we create that actually makes lawyers much worse writers, because the reality is there's only writing. There is persuasive writing, but really even, fiction writing, you're trying to persuade someone to love your story, right? And so when we section it off and say, well, there's legal writing, which is separate from the persuasive writing we've learned our entire life, suddenly you have people that maybe were good writers that become incompetent and think that they have to follow certain archaic rules that actually make their writing less persuasive. And you end up saying things like, comes now the plaintiff by and through X, because that's what legal writing is. But legal writing doesn't exist. And the idea that we segment off any part of it just makes us worse writers. And I think most importantly, takes away the voice that lawyers have and that people have, which makes your writing persuasive. If you're trying to write like every other lawyer before you, you're going to find that your writing sucks because your humanity doesn't come through in it and all, and no one wants to read a list of facts presented by someone in a very archaic and stylistic manner. It drives me crazy.
If we don't say that, how are we going to know who came and when they came?
I usually try to put a header on my briefs. It's a little weird thing. I don't know if everyone does this, but I put this header up there. It says who I am, who's filing the brief, and what the brief is. It's this novel concept we started a little while ago.
And then I sign at the bottom. I mean, who doesn't know the players here, people? I appreciate that. And what's interesting is we are going to have a conversation about writing generally and what that means for lawyers. And I had some thoughts about that. But before we get to that, tell me your background, because you had emailed me about your mom, which I was sort of fascinated with, and kind of therefore your approach to this question.
Yeah, so, I'm an attorney. I'm also the cultural ambassador of Palace Law in Tacoma, Washington. I do workers' compensation, personal injury plaintiffs work, which does involve a lot of writing, but also I'm a frequent writer. I love writing. When I grew up, my mom, for I guess now 35 years, I think, has been an English teacher her entire life. In fact, she was my English teacher for 1 year, which was slightly terrifying. But I grew up in a world where, writing was a big part of my life, and I still do it. So, in addition to writing briefs for my work, I also am a columnist for the ABA, and I'm going to be starting a column with the Washington State Bar Association now. I write for, various blogs for, bar journals, just because I enjoy writing, and I think it's a big part of being a lawyer, and I think it's, a great skill to have.
All right, well, let's nerd out a little bit, because we're talking broadly about using writing techniques, and we're pulling a lot of wisdom from fiction writers. So let me tell you a quick story that's going to relate back to what we're talking about. So as you know, I've been working on a book for a while, and it's about kind of the future practice from the solo perspective and what solos can do. It doesn't matter. The point is, the first time that I wrote it, it was boring, right? It was super boring. It was like a how-to, and there was a comes now so-and-so Bob at the beginning. Yeah. Nobody was coming, but you get my point. Like, it was super technical, really nerdy, terribly uninteresting. It's about the legal supply chain, for Pete's sake, just super nerdy. And then I ran into this book. It was a podcast, and then a book called Story Grid. And the author, who was a long-term editor, the short version that gets into what we're talking about is he argued that although there's not a formula for writing, depending on the genre of writing, there are conventions and obligatory scenes. So, for example, he would say if you're writing a love story, you have to have a breakup scene. No one will read a love story without a freaking breakup scene. You have to have that. You know, in Die Hard, you have to have the speech in praise of the villain, the time that Hans Gruber is like saying, I'm the man, and here's why. When you have genres, you have these conventions that are required. Bringing me back to Here Comes Petitioner Bob Jones. Legal writing is a thing in the sense that there are conventions and obligatory scenes, so to speak. And I wanted to kind of explore that idea with you. How do we tell people dude, stop writing like law is different, while also recognizing that in terms of what people expect, legal writing is different?
There are a lot of expectations around legal writing, and I think the thing I go back to is, will the audience care if that is not there, right? Like, do you think a judge will ever throw out a brief because it doesn't begin with "comes now"? Or is the judge going to be excited when your brief begins with relevant information to their reading? I clerked for 2 years during law school, or for 2 summers during law school, and I have to say, that's when a lot of these things kind of really hit for me, when I had to read a lot of other people's writings and realized how much of my time they were wasting by writing things like that. We'll talk about, Vonnegut is one of my favorite writers, and he has a lot of rules of legal writing. And one of his is that, or rules of writing, one is that every sentence must do one of 2 things: reveal character or advance the action. And I think the same applies to legal writing. If you're going to do it well, look at your conventions and ask yourself, is this doing one of 2 things? Is it telling them a fact that they absolutely need to know, or is it advancing my argument? And if it's doing neither of those things, I can assure you the judge will not mind if it's not in there. In fact, the judge will be pleased because you're not wasting their time.
Yeah, one of the things that we're going to do that you mentioned in this conversation is we're going to talk about some of these fiction writers, some of their tips. And the thing that you said about what's somebody going to miss, right? So it's from the perspective of the reader. What is it that they need? That's a fundamental principle of Story Grid. The reason he says make sure those conventions are in there is because somebody's going to read it and go, well, this doesn't quite work. Even if the reader doesn't know why it doesn't work, they'll say, boy, that doesn't work. And it reminds me of something that we'll talk about from Neil Gaiman, who's one of my favorite writers, who said, if somebody is reading your work and they say, this doesn't quite work for me, right? This doesn't feel right. They're probably right. If they then sit and try to tell you why it's not right and what you should change, they're probably wrong. But it's just interesting how with these conventions and with your experience with reading these briefs, even if you couldn't elaborate why it didn't work and what was bugging you about it, we just have this ability to read and feel when the story doesn't work.
Yeah, I had a conversation with one of the associates in my office just the other day as I was reviewing some writing of his, and I noticed that something when it was kind of repetitive, and it just felt repetitive, and I couldn't pinpoint a sentence and say this sentence is unnecessary. But I told him that, and I finally said, look, here's what you need to do. Something is wrong with this. I can't fix it for you. Go back, look at that, and ask yourself, what didn't I say in the first sentence that I felt I needed to say later on? Right? Because it's hard to say, but you can read something and, get a different perspective of it than when you're writing it. When you're writing it, it all flows out. When you read it as an outside person, you can start saying like, well, something's wrong here. This feels weird and giving a bad impression.
Yeah. One of the issues as I've done these interviews is I've sort of felt like we're not getting very tactical. We're in the clouds a little bit. I want to be able to tell somebody where a semicolon goes. And I sort of feel like that stuff is craft that comes if you are deliberate with it, if you have a grammar book next to you that just makes sure that you're on track. But the fundamental issue with lawyers seems to be we're not using rhetoric to persuade other people to our position, that we're getting in the way of the argument because of our own inability to communicate. Why do you think that's consistent with lawyers? Do you think there's something about the way we train lawyers in law school, maybe, like at the beginning, that just teaches us legal writing is somehow fundamentally different than writing generally?
There is. We talk about law as a profession as something fundamentally different. And in that we have these writing classes that, there are some really good ones that don't do this, but some of them kind of try to break down what you know about writing and teach you a new system of writing, whether that's IRAC or CREAC or whatever the, analogy they give you is. They try to teach you as something different. When you look at though, that's just persuasive writing. It's what people have done always. And it's just structured where you actually have laws instead of just, arguments and evidence you're trying to convince someone with. You're just using laws, but the structure is the same. And I think when you tell someone that something's different and new, they get the idea that what they've learned before they can't use anymore. And so separating it out instead of saying, here, let me continue your education in writing and improve the skills you have. When you say, let me teach you something new, people forget everything they had before them that, brought them to this point. And I think that's kind of, somewhat unique to lawyers in that what we do is just persuasive writing, but we take away the ability of ourselves to look at it that way and see it as something different.
So are you a fiction reader? Or are you much of a reader?
I am an avid reader. You can see part of my bookshelf behind me that is very full, and my house is a little bit insane when it comes to how many books you'll see on my wall.
My bookshelf is very full, but it does not mean that I read all of those things. We go to half-price books, and I just buy books, and people are like, "Oh, these look like really good reads," and I'm like, "I don't know. This is called my best intentions, man. Take the card and give me the book." Doesn't mean I read them.
95% of my bookshelf has probably been read by me, on all of them in my house as well. I'm a huge nerd. I read a lot of, in college I did a classics work where I studied most of the history of Western thought and a little bit of Eastern thought on my own during that time. But I love fiction. And I think, this part of this is instilled by my mom, who kind of reminded me of this, that fiction is really important, even if you want to learn how to write legal work or persuasive work, because most of history's greatest writing is fiction. There are the exceptions to that, but if you look at, Shakespeare, Austen, Cervantes, Homer, these are all fiction writers who, sometimes played with history, but in a fictional way. And in fact, one of my favorite examples of this is Herodotus, who wrote the book called The Histories, which gave us our modern concept of history. That had a lot of fictional stuff in it, and a lot of stories he told that we knew weren't true, but he told them as part of this book of history, because the reality is fiction is, the best writing that people often do is fiction writing, and the most persuasive writing people often do is fiction writing. There's a great book by T.H. White called The Book of Merlin, and in it he has a line where he just, some character is telling a story, and he gets corrected on all these little details, and finally says, well, it's true in substance, if not in fact. And I think fiction is what takes, us and allows us to speak truth without just reciting bulleted facts. It allows us to kind of expand our mind and create a world around this truth, instead of just saying, well, here's bullet number 1, bullet number 2. And that kind of creative writing, which doesn't have to be false, but creative writing is what fiction is, allows you to write better and more persuasively.
Yeah, I was thinking about this because last night my daughter Maya was going to school, and they were learning about railroads in Kansas. We live on the Kansas side now, and we don't have much. We have railroads, okay? This is our history that we talk about, because all the racist history we try to stay away from. Anyway, so she was looking at all this stuff about railroads, and she's like, why the heck am I memorizing? I'm never going to grow up and use any of this. And I explained to her, listen, you're learning about history and use of resources and the relationship with people and voting, because one day you're going to be in the middle of history, and the frameworks that you're using to make decisions, those are the same frameworks that you're going to use as a citizen. And I think, I can't say that I'm a big fiction writer myself, but when I got into that and I started really studying the genre effects and the conventions and those requisite scenes, and thinking through that process, it made me a better nonfiction writer. So when I went back to my book, the product of that book ended up being a lot better. And the same is true of judicial opinions and what lawyers are writing. When we bring in those frameworks, those ways of thinking, we're actually applying it to a new context in a way that really works.
Yeah, I love the term my mom always uses, not fiction writing, but creative writing, right? As something distinguished partially from persuasive writing. But fiction or creative writing doesn't have to be fiction. It can be creatively telling a true story, which is, what Shakespeare was known for doing in his history works, is creatively telling a true story. And I think that element of it is, it's not fiction, it's creative. And if you can be creative in your legal briefs, which is a good thing to do, you get more engaged readers, your judges or your clerks.
Well, what I want to do now is something a little fun to try to persuade people, go learn the reasoning of fiction writing to help your nonfiction writing. Use creative writing in your legal writing context. I wanted to go through some top tips from some fiction writers. You had sent me a link to Kurt Vonnegut, some of his top tips, and then it got me down this rabbit hole of looking at these other authors. So let's talk through some of those if you don't mind. Let's start with Kurt Vonnegut's. He said, actually the one that you had highlighted was, use the time of a total stranger in such a way that he or she will feel that the time was not wasted. So tell me about that.
So this one for me always is, thinking of my days clerking, right, is I would read sometimes 30-page briefs, and maybe 5 pages of it were valuable to me and helped me understand what was going on in the case, because there was so much filler or facts that I didn't care about. And it's, even if a judge isn't a stranger for you, when you're doing any legal writing, you're writing for a judge, you're writing for him to read it. And if they feel like they're wasting time, your argument starts to lose credibility, even if you've got a lot there. But if they're having to go through all these things that don't matter to them, they're going to start wondering, why am I hearing about these things if they don't matter to me? Are they trying to point me in a different direction? What's going on there? And a judge shouldn't feel like their time is wasted reading their brief. A judge should feel like every minute they spend reading your brief, every sentence they read adds value to them, helps them with the job they have to do, because that's what you're doing when you're writing for a judge. You're trying to help them make a decision, help them do their job. And if you're wasting your time, you're hurting them doing their job. So it's really important to think about in your writing, what matters. And, sometimes looking at every single sentence and asking yourself, does this sentence advance the action? Does it explain a character? What does this sentence do? And do I need to do it?
Yeah, one of my favorites is Elmore Leonard, and his line on this is never start a book with the weather, right? Like so many inexperienced writers will start with, it was a dark and stormy night, and we tend to do that in these legal opinions. And his point was, don't start with the fluff, right? Like, let's get into, there's another Neil Gaiman book, I think it's The Graveyard Book, where he says something to the effect of, it was dark and a man held a gun, right? And it just starts this story on, we're into the story. Who cares what the weather is outside? And related to that, I wanted you to read to me another Vonnegut line, the one about suspense.
Oh, yes, I love this one. So he says, give your readers as much information as possible as soon as possible. To heck with suspense. Readers should have such a complete understanding of what is going on, where, and why that they could finish the story themselves should cockroaches eat the last few pages. It's a long one, but I love it because one thing I often think about, and part of this, comes now structure that we have in brief writing, is we're building up to our conclusion. That shouldn't be the way we do it when legal writing. The judge should be able to read the first paragraph and know everything they need to know to finish your brief for you and to rule in your favor if they can. So, a better way than starting out with comes now, or even, we are filing this motion for summary judgment. Please see our arguments below. Start with the end. Just cut to the point and say what needs to be said. Speaking of great fiction writers, Dickens has a line in A Tale of Two Cities where he describes a great lawyer as having his arguments at the tips of his fingers. And I always think about that. If I had to say in one sentence, what is my argument? I should win because X. How do I finish that sentence? And then, surprise, the first sentence of my brief tends to be, the plaintiff is entitled to summary judgment because X. And I give them the facts they need and the law they need in that one sentence. And there they have everything they need to know. And they know where they need to look to fill that in. Of course, I give them everything in the rest of the brief. But a judge isn't left guessing, like, how is he going to make the argument for summary judgment? How is he going to satisfy this element? I tell it in the first sentence or the first paragraph at the most. And that gets it all out there because suspense doesn't help you in something like this. They want to see how you get there. And, they want to know right away and then fill in what information they need as they go through the rest of it.
Yeah, this reminds me of my time as a trial attorney. I would always tell clients, when we go into court, the judge is going to listen to maybe 5 minutes of what we say, and then he or she is going to put us into a bucket. Most judges really, they don't have the time to process each case as an individual, totally new experience. And so what they do is they listen to that first bit, to the meat that's in that, and then they kind of line us up with those conventions and required scenes, and they'll say, basically, what kind of story is this? What kind of book is this? They know within 5 minutes, is this a mystery? Is this a love story? Is this a murder? You know what I mean? The analogy there seems obvious to me when I'm doing oral argument, that I've got this tiny attention span and I've got to make sure they know what this case is really quickly, so they put me in the right bucket. The same seems to apply with our writing.
It really does. And, I think clerks are a good example of this. Judges are thoughtful, the clerks are thoughtful. They're going to be looking up everything you say. They're not going to just read your brief and assume that everything you say is right. But they're going to be thinking about it as they go through it. So if you open up with, here are the things I'm going to lay out, the entire time they're reading it, they're going to be thinking, wait, how is he going to prove this thing? Oh, I get to the end and I finally see it after I've been thinking about it for a long time myself and might have my own opinions. If you open up with, I'm entitled to summary judgment because X, and you hit the elements, then a clerk's going to be going, well, yeah, they're right. Let me confirm that they have the supporting information behind that, and now I'm on their side, right? Don't leave questions to them. Don't leave questions to the reader. They don't add value to it. And with stories, it's the classic stories of, any romantic comedy, right? They're going to end up together. That's never the question in the story. People watch them because they want to know that they're getting together and kind of confirm that through a unique process. Suspense doesn't add anything to those stories in any real way. And the same is true of persuasive writing.
Yeah, let me give you another line that's one of my favorites from Elmore Leonard. He said his general rule is, if it feels like writing, if it sounds like writing, I rewrite it. What do you think he means by that?
I love that because especially with persuasion, but fiction too. If you are writing and someone can look at this and be like, oh, they're trying to write to me instead of having a conversation with me, it's less persuasive. Anything I write and put out there, I will always read out loud to myself in my office, usually with my litigation paralegal listening in the next room, telling me if something sounds crazy. Because what I will find is that I can write something and it sounds totally reasonable. And I read it out loud and I sound like an alien trying to convince people that he's actually a human. Because things can flow out on paper, but when you say them out loud, it's not how you talk. And if something sounds like writing, it sounds forced and it doesn't come across as persuasively. If it just sounds like you're talking to someone in a room with them, having a conversation with them, it reads easier, it reads better, and it's more engaging. If someone is noticing that, oh, this sounds odd, this sounds like writing, they're going to be pulled out of the story. And in fiction, you don't want someone pulled out of your story. You want someone to feel like they're there, a part of it the entire time. The same is true of persuasive writing. You don't want someone to be stepping back and saying, wait, what is going on here? That you want someone to be reading through it and following and just nodding their head, agreeing with everything you say.
Let's do a couple more that have to do with process, because I think this is fun. Margaret Atwood, who has done poetry, and she's famous for Handmaid's Tale, but has written quite a bit of poetry, actually. She said, when you get to work, when you get to your writing, you'll likely need a thesaurus, a basic grammar book, and a grip on reality, which is just an awesome sentence. What do you think she means by that?
I love all of that. Writing is work. I don't have a thesaurus in my office, but I do use Google frequently for that very purpose. It takes time. And, a lot of, especially solo small firm attorneys, don't feel like they have the time to write well. And that's the reality, is writing well does take a lot of time, and it's work and it's effort. But I think there are little things you can do to kind of enhance that, right? Like have a thesaurus around to Google things really quickly and just, find a better word for something. It takes 10 seconds. It'll help your writing. I think, take a moment in your writing to add a piece of flair. Focus where it matters. Focus on your first sentences. Make sure those are good, because that's where you're going to pull someone in. And if you engage them in the beginning, pull them in on the first sentence, they're going to stay through for a while in the book. There's you mentioned first sentences earlier. There's a great fiction book by Tom Robbins. The opening line is something to the effect of, the abandoned briefcase full of underwear was found in the river. No one knew quite what it meant, but we believed this could change the world for the rest of us. And it was this, it fit to the story, but it was this thing that you read this and you're like, okay, now I'm curious to see what this is all about, right?
Right.
It engages you. So focus on your first sentences when you don't have time. And the other thing I tell people when they don't have time is just take a moment, 5 minutes to add a bit of flair, something to engage people into the writing. One of my favorite things is, you can maybe see back on my bookshelf, I have a book, it's too hard to see, called The Quotable Lawyer, which just has a lot of great quotes from history about, legal thoughts, legal ideas, legal concepts. And I have a strong tendency to go back to that and pull something out when I think it's relevant and, useful, and can just kind of insert a bit of, flair to the writing, because as you're reading through it, it can get rather boring. If you can kind of pull something in to make the reader, wake the reader up a little bit, I think that helps in a lot of ways. So yeah, it takes a lot of work to write. And I know lawyers can't always do that. So I'm not going to tell you to spend, 5 hours just on the editing phase of every single brief you write, but take 5 minutes and make sure it's good and engaging, and add a little bit of flair to make something matter. And I tell you, I've used those quotations. I've had judges comment multiple times on those, because they remembered that quotation that I used. They thought about it. It pulled them in. It made them wake up from their reading. And I've had them comment on it multiple times, never negatively yet.
Well, and I will have to say, as a former family lawyer, a disturbing number of my briefs probably could have started with, there was a briefcase full of underwear. That's a different story for a different time. I did want to point out one other. I wanted to say that the Margaret Atwood quote I really like, because she says, you're starting with a thesaurus and a grammar book and a grip on reality, meaning what we think of as the hard part is not really the hard part, right? Like, she's not saying, go learn all the technicalities of where the semicolons go. Have a freaking book for that next to you. What you really need to do is spend the time learning the craft and that storytelling. What I find fascinating about that, and what we talked about with how stories feel and whether they feel right or not, is the important part of stories is actually a very human exercise. Like, we all innately know these things. We know what good stories look like. Maybe we get it from Netflix, maybe we get it from literature, but the point is we know what good stories feel like, and we can bring that to our own writing and let the thesaurus do the rest of it. The other thing I wanted to mention finally from these prose is Neil Gaiman. I recently heard an interview with him. He has a habit of, he decides that he'll block out his writing time, and he says, during this time, I'm either writing or I'm doing nothing. Those are his only two options. So he'll sit in a room, he doesn't have his phone, he doesn't give himself permission to play with the kids or to talk to the dog or to look on the internet. It's writing or staring off into space. Those are his options. What do you think about that writing habit and getting into doing that no matter what?
I love it. Roald Dahl, actually, great author, used to have a little shed, and it was his writing shed. And he would go in there, and he had this little kind of cozy corner he made for himself in the shed where he had a teapot because he was British, and this big comfy chair and a little desk that pulled up over this recliner. And he would have notebooks and pencils and a sharpener because he wrote everything by hand. And he would just go into the shed, and that's where he was for the next 4 to 8 hours, in this little shed, and where he had, no internet, nothing to do. It was, I'm writing, or I'm sitting in this chair staring at my piece of paper or taking a sip of tea, because he had his little world he'd created himself to write. And I think you kind of need to do that sometimes if you're going to write. When a brief is coming due and you've got 10 million things, especially as a solo small practitioner, that you've got to do, set aside time, lock your doors, turn off your Wi-Fi and say, I'm going to write this now, and do it. Because when you dedicate yourself to that, sometimes people get writer's block. I'm guilty of this too. And the trick I like to do to break this is just start writing. And it will be absolute garbage and it will be awful, and I will undo all of it. But 3 paragraphs in, I'll start figuring out what it is I want to say, because I've written everything I want to say poorly. Now I've got it out there, and I can look at that and say, oh, what I meant to say, what I wanted to say is actually this little part of it, and let me rewrite that and make that better. And if you create a world for yourself like that, where you have nothing to do but write or not, you're going to end up, writing probably.
Yeah, you'll get something out because you'll go crazy otherwise.
Yeah.
So I think there's a lot of wisdom here from the masters. I want to get to some quick shot questions and maybe some summary questions that we'll use later. Let me ask directly and see if we can answer this succinctly. Why should lawyers read more fiction?
The greatest writers in history are almost all fiction writers. Fiction teaches us how to write creatively, and creative writing is essential for persuasive writing.
Great. We had talked about the conventions and the obligatory scenes. How do lawyers figure out how to check those boxes to get those obligatory scenes and conventions in their writing, but other than that, to focus on the craft of the language and make sure that we really get to those focused parts that are necessary? How do we figure out what those obligatory scenes are?
I think you have to think about each thing on whether it matters to the judge or not. And I think the best way to do this is to break down, if you're really doing it, every sentence, and look at each sentence and ask yourself, okay, does this sentence, stripped away from context, what does it do? Does it introduce facts that need to be introduced? Does it advance my argument? If the answer to both of those is no, cut it, because the judge doesn't care about it. Your convention is to be persuasive, and there are these, rules and formalities. But I can tell you from experience, the judge isn't going to get mad at you if you cut them out, because as long as you are being persuasive, giving them all the facts they need, giving them all the argument they need. And yeah, you need to have an issue statement, right? But look at your issue statement and ask yourself with each sentence of it, does it tell a fact that needs to be told? Does it advance my argument? And if it does neither of those, rewrite your issue statement.
Yeah, and frankly, it may be that lawyers were so thoroughly trained on writing those conventions and obligatory scenes that maybe we shouldn't worry about that being the issue right now, right? Like maybe the pendulum should swing more to creativity, and we'll get to a middle place of that.
Pretend there are no conventions and ask yourself, am I giving all the facts needed? Am I making all the arguments needed? And also limit yourself on the arguments that are needed. Sometimes we think we need to go broader than we have to. I remember one time I had a case where, the opposing counsel cited to a Wittgenstein quote that I knew and recognized was out of context. And so then I had about a half-page long footnote explaining, what that quote was in context and how they'd completely misconstrued this. And thankfully, my boss, Patrick Pallas, pulled me aside and said, yeah, I'm cutting all of this because, while it's, nice to show that you're smarter than them, it doesn't really help them judge at all.
And so I'm pretty sure it's not Wittgenstein. I think it's Wittgenstein. Did you get that? That was a Dr. Frankenstein reference. So final question. One of the things that I've seen coming up as I've talked to lawyers about writing in our context is that balance, right, between brevity being the soul of wit, to quote Bill Shakespeare, and this need to show a little personality. Any recommendations on how you might balance that, having your personality and your voice, but still remembering that brevity matters?
Yeah, it's tough. Like, that last story is a good example of that. My personality and voice got a little too far there. I think always focus on what's helpful to you, right? And sometimes a little extra voice is helpful because it's engaging, and it's okay to include something because you think it will engage. When it comes to really any rules of writing, and since we talked about Vonnegut, I should say he famously said that the greatest writers tend to break all of his rules, right? It's true, you have to have these rules, you need to know these rules. And when I was a kid with my mom as an English teacher, I kept, harassing her that, well, all the great writers break all the rules she was teaching me. And she said, yes, when you are one of them, you can do that as well. Because the reality is you need to understand the rules deeply. You need to understand why they exist, what their purpose is, what they're for. And when you know them really well, you can break them, because then breaking them is an intentional thing you are choosing to do for a specific purpose. But only if you really know the rules, like brevity, and understand why brevity is important, can you decide, well, yes, brevity is important, but in this one spot, adding this little extra detail to my case, to my statement of facts, will make a difference, will engage the reader, and will serve the purpose of the rules. That's when you can do it. But only when you really understand the rules can you start to break them and play with them. But once you do, break them as much as you want.
All right. Well, Jordan, I really appreciate you sharing these thoughts, and I agree with you that it's important to read more fiction. I will make sure to address some of the many books on my bookshelves. It's fine. If somebody wants to get a hold of you, dear cultural ambassador, what's the best way for them to connect with you and learn more about your take on writing and on practice generally?
Yeah, I'm happy to talk about writing or practice or tech or anything. The easiest way to get in touch with me is probably on Twitter. I am at Jordan L. Couch. You can also email me, though, jordan@palacelaw.com. Find me on Facebook, Instagram, LinkedIn. There are a million ways. You can call the office if you really want to get a hold of me. I'd love to talk about this kind of stuff and anything I can do to improve the legal writing so the clerks of the future don't have to suffer through what I did.
Good man. I appreciate you. And thanks to everyone for watching Insights from Case Text. I'm Mike Whalen. We will see you next time when we talk more about writing with our friends. Have a good one.